The fourth issue is whether the court has the discretion to look beyond the words of the agreement to the actual facts of the case. Next, the issue is whether the increasement of the selling price with deferred payment pursuant to the Islamic Banking Act 1983 or the Banking and Financial Institution Act 1989. And last but not least, the issue is whether the plaintiff is entitled to return back to the original facility amount they had extended. Thank you. That's all for me. I will pass to the next presenter. These are the legal issues in this case, which are whether the civil court will become a Sharia court when engaged with the case of Islamic financing facilities, although whether there are any other elements thereabout that prohibit the agreement of a loan, and whether there are another term of al-ba'i bidhaman ajil other than sale and deferred payment. Assalamualaikum, good day to Dr. Alias. My name is Nadhirah binti Zulkifli with matric number 280547. Today, our group will analyse for the case of Arab-Malaysian Finance Berhad against Taman Ihsan Jaya Sdn Berhad, Koperasi Seri, Kota Bukit, Cheraka Berhad Third Party 2008 5 MJLJ 631. This case is a High Court case in which the judgment was made on 18 July 2008 by the Judge Abdul Wahab Patel J. So the plaintiff in this case is Arab-Malaysian Finance Berhad, while the defendant is Taman Ihsan Jaya Sdn Berhad. So this case involves al-ba'i bidhaman ajil transaction and the jurisdiction of the civil courts pertaining to this issue due to Malaysia's constitutional arrangement. There was a property purchase agreement and property sale agreement entered by defendants and plaintiffs. So the relationship between parties is buyer and purchaser. The defendants agree to pay in installments with the security they need to execute the charge of the property to the plaintiff. So the plaintiff shall submit to the court for the foreclosure and civil remedies against the debtors of the plaintiff bank. So the court held in favor of the plaintiff by ordering a sale by public auction of the charged properties.
It is common knowledge the main principle that governs Islamic financial transactions is the ban of interest, or better known as riba. In the instance of this present case, the defendants had already paid a portion of the amount of a purchase price to buy a property from a third party. When they needed a facility to finish the transaction, they went to the plaintiffs. What happened was that, in accordance with the terms of the Plaintiff Bank's Property Purchase Agreement, or better known as PPA, the plaintiffs demand that each of the defendant sell the property he had purchased to the plaintiff banks for the remaining balance of the purchase price.
However, in accordance with the bank's property selling agreement, or better known as PSA, the plaintiffs later sold the property back to the appropriate defendants who promised to pay a set amount of monthly installments. In consequence, the plaintiff was entitled to a charge or assignment of the defendant's property as security. What happened next was that, according to the plaintiff's usage of the term ba'i bitamim ajil, the total of the agreed upon installments tallied up to the bank's selling price under the transaction. Due to the defendant's failure to pay the bank's selling price, the banks requested a court order authorizing the sale of the charged property. The defendants then argued that this transaction, which included the letter of offer, the PPA and the PSA, as well as the charge or assignment in question, became transparently financing in nature, which came off seeming like it was actually transacted for the purpose of merely profits. Because of this, they pleaded with the court to determine and examine the transaction to see if it contained any elements that were not permitted by Islam or whether it had violated the terms that were stipulated under the terms of Islamic Banking Act 1983 or the Banking and Financial Institutions Act 1989. This situation has actually further caused confusion over how the initially agreed upon selling price under a ba'i bitaman ajil contract should actually be interpreted. Thus, when making decisions about issues involving Islamic funding, it also became necessary to take the role of the civil court into account.
Good day, Doctor. I'm Ivy Charmay of metric number 280827, and I'll be presenting the authority of the case. Firstly, the key concept in this case is the BBA. Bank Negara Malaysia defines BBA as a deferred payment sale whereby the financier purchases the property requested by the client and then sells the goods to the client at an agreed upon price that includes a markup profit for the Islamic bank. The selling price is fixed and agreed upon by both parties, and it will remain unchanged until the end of the payment period. The ownership of the property purchased will be under the claim of the financier and will be transferred to the customer upon full payment. The first provision used is Section 66 of the Contract Act 1950. This provision means that it is a must for the party receiving benefits from the agreement that is discovered or proven to be void to restore the benefits. The second provision is the Article 74 of the Federal Constitution. Article 74 provides that finance, including banking, are subject matters within the federal list and they are within the jurisdiction of the civil courts, while matters relating to the religion of Islam are within the state list, which are within the jurisdiction of the Sharia courts. This jurisdiction, no limitation in respect of the states and the Sharia courts means that cases involving Islamic financing in Malaysia remain within the federal legislative jurisdiction, and cases relating thereto are brought in the civil courts. No legislation in the form of Islamic law has been made for trade and financing based upon Islamic principles. Thirdly, Section 256 of the National Land Court. This provision provides the power of the court to grant an order of sale of charge land upon the application of the chargee. According to Section 257, subsection 1 of the National Land Court, if there is any default in repayment, the chargee is entitled to enforce his rights in obtaining a judgment and apply for an order of sale for the charged land. Once the order is granted by the court, the sale must be conducted through a public auction. The proceeds of the sale is used to settle off the debt due. Lastly, Order 83 Rule 3 of the Rules of Court 1980. The order only applies to a charge action in which the plaintiff is the charger and claims delivery of possession or for payment of money secured by the charger or both. The rule says clearly that it applies to an application for delivery of possession and for payment of money secured by a charge, but does not say it is applicable to an application of an order of sale.
My name is Muhammad Irfan and I will be discussing the important principles highlighted in various Islamic banking cases. Let's begin with our first case. The case of Afin bin Sina Berhad vs Zulkifli raised essential principles regarding the interpretation of contractual term and calculation of selling price in Islamic banking transaction. The court emphasized the equitable interpretation and the need for a fair and just selling price that adhere to Islamic finance principle. It also considered to be the prohibition of riba interest and the importance of formal sale and bona fide transaction. Secondly, Cik Omar bin Cik Soh vs PP. This case recognized Islam as a comprehensive way of life, covering all aspects including legal, political, economic, social, cultural, moral and judicial. It emphasized the importance of maintaining substance over form and focusing on the reality rather than mere labels in legal matters. Moving on to our next case. The application of Section 256 of the National Land Code in an Islamic financing facility, the court emphasized that Islamic banking facilities are subject to the same laws and principles as conventional banking. Remedies are also provided under the NLC was addressed in Bank Kerjasama Rakyat Malaysia vs MC Corp. In Arab-Malaysian Merchant Bank vs Silver Concept, it involved the intersection of Islamic and common law in the context of agreement and foreclosure proceeding. It highlighted the constitutional protection and enablement of both Islamic and civil law in Malaysia. While in BI Credit and Leasing vs Lu Wahi and another, it involved a novation agreement and the transfer of obligation from a vendor to a bank and then sold to a customer. The court acknowledged the criticism of such arrangement as potential distortion and criticizes practices solely focused on profit. Let's explore another significant cases. The case of Malayan Banking Berhad vs PK Rajamani examined a new facility granted by a bank to a borrower with a different interest rate. The court emphasized that the importance of looking beyond the label and considering the substance of the agreement. The focus should be on the actual facts and the true nature of the transaction, rather than just the terminology used. Our last case resolved around an interesting aspect of Islamic finance. In Bank Islam Malaysia Berhad vs Adnan bin Omar, it focused on the interpretation of Islamic banking transaction and the obligation of the parties involved. The court held that the defendant is responsible for fulfilling the terms of agreement based on the defendant's knowledge and voluntary acceptance of the agreement. It also examined an al-bay bisaman no-ajil transaction and raised concern about the interpretation of the selling price, which imposed a greater burden than a conventional loan with interest. Thank you for your attention. Now I kindly pass the spotlight over to Ainnur.
The judgment held for this case is that the court ordered that the charged properties be sold at a public sale and paying the cost of doing so. In short, this court has decided that even though they use the words Islam and religion of Islam, the Federal Constitution, the Islamic Banking Act of 1983 and the Banking and Financial Institution Act of 1989 do not say which school of Islamic law, in bracket mazhab, should be followed. The Al-Baqi Bitaman Ajil facilities are set up according to Islamic principles. This means that all Muslims can use them, no matter which mazhab they follow. So, we can assume that the test is based on whether or not there are any parts that do not follow the tenets of Islam as defined by any of the recognized mazhabs. So, it can be assumed that other school of thought do not agree with the reading the PPA and PSA separately, even though the Shafi'i school of thought does. So, we can say that the PPA and PSA cannot be read separately from the Islamic Banking Act of 1983 and the Banking and Financial Institutions Act of 1989. This fits with the most important belief in Islam, which is that Allah knows everything. In cases involving Islamic finance facilities, it is important to remember that the civil court can only do what it can do as a civil court, not as a Sharia court. The main job of the civil court is to make a formal decision based on the laws that apply, not to apply Islamic law as if it were a Sharia court. The main goal of this institution is to keep an eye on how Islamic principles are put into practice and make sure that all transactions that fall under its control carefully follow the rules of Islam and do not include any parts that aren't allowed by the religion. In the setting of Islamic finance, there are no clear rules that say loans cannot be given. The only part of the loan that is against the law is the riba. So, it is okay to give loans that do not charge interest, like Qard al-Hasan or charitable loans. The term Al-Baqi Bitaman Ajil refers to a transaction in which the sale of a good or service is followed by a plan to pay later, which both parties agree to. So the buy price is usually sent back when the product is received. Still, if the payment is not made right away, the seller is basically giving the buyer a loan or credit for the amount of the sale. The court has the power to look at more than just what is written in the deal. It can also look at what happened in the case. It is important to look past the words used and get to the heart of the matter. This is especially true when you consider that the plaintiff's meaning caused the defendants to have much more debt than they would have had they chosen a conventional loan with interest.
Next, I am Suraya of the Termizi. Nama metric 280997. I will be explaining the analysis of this case. So, most Islamic finance products in Malaysia were based on the Baik Bitaman Ajil contract when this case was resolved. Because of that, the judge's judgment shook the Islamic finance industry. The ruling challenged the Islamic financial industry in every way, not only legal and regulatory. So, some of the scholars and professionals has voiced their support and opposition to this case conclusion. Firstly, according to Professor Dr. Ashkar Ali bin Ali Muhammad, the BBA product offered to Muslims must not conflict with Islamic principles, and a dispute over whether the BBA scheme is Sharia compliant is determined not only by reading the property sale agreement independently, but also by going beyond the actions and words during the agreement to regulate the actual facts of the case and the constituent of the transaction between the parties. The Holy Quran and Hadith are the fundamental sources of Sharia or Islamic law are used to determine it. In this particular case, the federal court ruled that the plaintiff was not a bona fide sale but a financing products or financing transaction. Thus, this looks grossly unjust, but the courts can use reasonable rules to correct inequalities. Next, we're moving on to another professional, which is Fakihah Azahari, an attorney and solicitor, also Sharia audit, noted that 4 crucial concerns were not brought to the court notice in this case. Firstly, contrary to the court's understanding, there are actually additional laws that may be used in Islamic banking and commerce transactions. Second, Fakihah noted that in Malaysia, various state law enactments clearly specified for the statutory meaning of the term syarak, which concerns any of the accepted mazhab are part of Sharia. Thirdly, there are various conflicting viewpoints on riba. And lastly, there is a fair technique to calculate the sale price incorporating ibrah. She also found that BBA case structure court finding flawed and harsh. That's all from me. Thank you.